All right, what's happening, people? We're about to get this thing started. Let's get going. Let's get going. We'll waste no more time. Let's get it going. All right, let's get busy. We're going to continue the Supreme Court oral argument debate on this birthright citizenship. And then we're going to get into what some other people think. And we're going to look up some of these keywords that they were talking about from the previous review we did yesterday. All right. So where is he at? All right, there you go. Is that it? All right, so we're going to start from where we left off at with Justice Brett Kavanaugh. And then we'll take off from there.
Which refers, as you know, to constitutional ruling you want from this court, win, lose, or draw.
Yeah, we think that the statute and the Constitution means the same thing. If the court disagrees, obviously we prefer an adverse ruling. If the court's going to do that on a statutory basis and a constitutional basis.
But you just disavowed that in your responses to me by saying that that's not an available option. That's the way I understood it.
Yes, the court would have to disagree with our statutory position, which is that it means the same thing as the Constitution. But if the court were to do that, then the natural course would probably be to rule on statutory grounds alone. Now, we think they mean the same thing, and we've got arguments for that, including, I think, the analogy I just referenced.
Thank you.
Justice Kavanaugh?
General, how should we think about the text of the 14th Amendment, subject to the jurisdiction thereof, as distinct from the different language of the Civil Rights Act of 1866, which refers, as you know, to persons not subject to any foreign power? Those texts are, on their face, different, and the history that Justice Kagan referred to might have developed quite a bit differently if the 14th Amendment's text had used the phrase that was in the Civil Rights Act.
That's an excellent point. And this court has held in multiple cases, Hurt against Hodge and General Building Contractors, has recognized that they're intended and they did mean the same thing. And that's powerfully reinforced by the congressional debates, where really what they're discussing is they said they were dissatisfied with the language in the Civil Rights Act because the phrase Indians not taxed they thought was ambiguous. And so they switched to the affirmative statement as opposed to the negative statement. The affirmative statement is subject to the jurisdiction thereof, but there's express statements in the congressional record essentially that we're doing the same thing. And that is what.
Slow down. Man, this dude be talking fast. Let's go back to the Indians not taxed. Saying it's ambiguous, right? They're using the word ambiguous. So let's back up just a little bit. I don't know how to. Guys, make sure you guys repost. Everybody that's in here, peace to everybody. welcome, greetings. Let's run this back a little bit.
Statutory basis than a constitutional basis.
But you just disavowed that in your responses to me by saying that that's not an available option, is the way I understood it.
Yes, the court would have to disagree with our statutory position, which is that it means the same thing as the Constitution. But if the court were to do that, then the natural course would probably be to rule on statutory grounds alone. Now, we think they mean the same thing, and we've got arguments for that, including, I think, the analogy I just referenced.
Thank you.
Justice Kavanaugh?
General, how should we think about the text of the 14th Amendment, subject to the jurisdiction thereof, as distinct from the different language of the Civil Rights Act of 1866, which refers, as you know, to persons not subject to any foreign power? Those texts are, on their face, different, and the history that Justice Kagan referred to might have developed quite a bit differently if the 14th Amendment's text had used the phrase that was in the Civil Rights Act.
That's an excellent point. And this court has held in multiple cases, Heard against Hodge and General Building Contractors, has recognized that they're intended and they did mean the same thing. And that's powerfully reinforced by the congressional debates, where really what they're discussing is they said they were dissatisfied with the language in the Civil Rights Act because the phrase Indians not taxed, they thought was.
All right, so they're talking about the Civil Rights Act. He mentions this. Okay, so they're talking about Civil Rights Act, but what the Solicitor General does immediately jumps to the language Indians not taxed. Now, just to give you guys a background, Article 1, Section 2, Clause 3 has the language of Indians not taxed, and that's dealing with enumeration. And in Article 1, Section 2, Clause 3, you can look that up, where it says enumerated so and so forth, excluding Indians not taxed. So the ambiguous part of it, if anything, will be, who are these persons? Because the Constitution, the articles within the Constitution in Article 1 don't mention anybody in there but Indians. In the Commerce Clause, Article 1, Section 8 as well, it talks about regulating commerce with the Indians. Regulating commerce with the Indians means they're regulating their citizens in commerce with the Indians, making sure there's no violations of any agreements, treaties, friendship ties that they have. Now, the ambiguous part is who are considered to be persons, because that's what this justice is asking, this persons thing. And this is subject thereto, or however he framed it. Who are they talking about? I mean, if these aren't considered to be people, because as I showed in previous presentations that I've done, persons are individuals, corporations, trusts, estates. Sometimes can be applied to departments, governmental entities, agencies, offices. On top of that, the executive order 6103 or 6104, 6102, one of them three numbers. The suspension of the gold standard is that it only applied to persons, and those persons was considered to be the same thing. Where they say associations, partnerships, corporations, associations, partnerships, everything that you will find on an SS4. If you're getting a federal employee identification number, you will find those categories to check. C Corp, S Corp, sole proprietorship. That will be considered an individual. Partnership, that's where you get your LLPs or LPs, limited liability partnerships, limited partnerships, LLCs. Those are associations, because in order to set up an LLC, you have to create articles of association. So this is what we're talking about. These are not considered to be people with arms, legs, nose, mouth, ears, eyes. These are entities. All right. So what we're going to do, because this Kavanaugh, right, what he's attempting to do is try to bring everything that was said prior. That's all the justices. Keegan, Sotomayor, what's the lady name? Ketanji, Thomas, Justice Thomas, Amy Coney Barrett. He's trying to. It seemed like he's trying to sum up all of these people's questions in one to try to get to the main aspect. And the other thing that is to point out as well is that Civil Rights Acts, right? 1866 was the first one. A whole 100 years later, you have more Civil Rights Acts, and then they jump right to the Indians. Just pay attention to that.
Thereof as distinct from the different language of the Civil Rights Act of 1866, which refers, as you know, to persons.
Well, now we think they mean the same thing, and we've got arguments for that, including, I think, the analogy I just referenced.
Thank you.
Justice Kavanaugh?
General, how should we think about the text of the 14th Amendment, subject to the jurisdiction thereof, as distinct?
I'm just going to pause it. I ain't saying nothing, just so you can catch it.
From the different language of the Civil Rights Act of 1866, which refers, as you know, to persons not subject to any foreign power. Those texts are, on their face, different, and the history that Justice Kagan referred to might have developed quite a bit differently if the 14th Amendment's text had used the phrase that was in the Civil Rights Act.
That's an excellent point, and this court has held in multiple cases, Heard against Hodge and General Building Contractors, has recognized that they're intended and they did mean the same thing, and that's powerfully reinforced by the congressional debates, where really what they're discussing is they said they were dissatisfied with the language in the Civil Rights Act because the phrase Indians not taxed they thought was ambiguous, and so they switched to the affirmative.
Well, I got to say something about this one. So the 1866 Civil Rights Act had something to do with the 14th Amendment. And it also was an amendment to Article 1, Section 2, Clause 3, really Article 1, Section 2. You have your different clauses, Clause 1, Clause 2, Clause 3. The 14th Amendment, Section 2, has the identical language that you will find in Article 1, Section 2, Clause 3. Just so you know. There's a little bit of a twist, but it's pretty much the same thing.
Affirmative statement as opposed to the negative statement. The affirmative statement is subject to the jurisdiction thereof, but there's express statements in the congressional record essentially that we're doing the same thing, and that is what this court's case law has reflected.
Why didn't they say the same thing?
Again, it appears they preferred the sort of positive formulation subject to the jurisdiction thereof as opposed to not subject to any foreign power. And again, there's a deep concern and lengthy discussion of the potential ambiguity in the Civil Rights Act. They want to eliminate an ambiguity, but do the same thing. And I think that that's very strongly reflected in those debates.
By the time of the 1940 and 1952 congressional actions, where Congress repeats subject to the jurisdiction thereof, given Juan Camargue, one might have expected Congress to use a different phrase if it wanted to try to disagree with Juan Camargue on what the scope of birthright citizenship or the scope of citizenship should be. and yet Congress repeats that same language knowing what the interpretation had been. So how are we to think about that?
I think baked into that question is an understanding, I think that was reflected in Justice Kagan's earlier question, that everybody understood that Wong Kim Ark meant that, and the history I talked about, I think refutes that. That really there's a consensus that goes our way for decades and decades after the adoption of the amendment and after Wong Kim Ark on the specific question of the children of temporary visitors. And it's really not until, and again, and their author in 1921 is saying, hey, the other side is the consensus.
I'm sorry.
Yeah, sorry, go ahead.
But there's executive branch interpretations and others. And if you're in Congress in 1940 and 1952 and you want to limit the scope of Wong Kim Ark or to eliminate ambiguity, why do you repeat the same language rather than choosing something different? For example, you could use the language from the Civil Rights Act of 1866 or some similar formulation if your idea in 1940 and 1952 was to not have ambiguity or not have an overly broad scope.
I think if you look at the structure of that statute where it's 1401A and then B through H, A, and it says these are the people who are entitled to birthright citizenship. A is the constitutional standard, and then B through H are all the categories that Congress has super added to that. I think the natural inference is that Congress is codifying, which it was consciously doing in 1941, pulling all the naturalization rules and immigration rules together into one statute and said, you go to one place, here's who is a birthright citizen. A, those who are guaranteed that right by the Citizenship Clause, and B through H are the ones that Congress has added through its naturalization power. So that inference to me says A is merely, it's not trying to change or alter the constitutional standard, just saying, hey, the baseline is what the Constitution says, and we codify that, and then we move on to the new categories.
Of what relevance, if any, do you think?
Now, basically what he just said, the Citizenship Clause. So the Citizenship Clause, last time I checked, is the Naturalization Act. Right? So we'll look at the Naturalization Act. I'm just making bookmarks. We're not going to look at it now, but we will look at it. Right? We're going to look at it. So we just take a quick note of that one. Because he said A, that is under this Citizenship Clause, and then B through H, people that they consider to use their powers, right? Because he used the word powers. And this is what I talk about, these plenary powers that they're doing through executive, what you call fiat. What they do is now is they utilize Article 2 in terms of an emergency powers in order to create executive orders. So when there's emergency power, emergency situations going on in regards to, and this is why they run a whole play and got people thinking that Trump is doing what he ain't supposed to be doing, is that under an emergency, Article 2 takes over. The executive branch takes over. Why? Because they're the enforcement branch. They enforce the law. They enforce what Congress has put forward, the precedent that comes behind that, and the executive branch enforces it. So when there's emergency powers, everything stops. This is why most presidents are really presidents. This is why Roosevelt did 4 terms. Because he could not be stopped. Once you do executive order, once you raise that there's a national emergency, that means it's wartime. There's a problem. There is an infiltration of the border. Something is going on inside the border dealing with either foreign and or domestic. That there's an enemy here. That's where you got the Alien Seditions Act, the Alien Enemies Act. You have all these different acts that's going through that actually has been pushed by the executive branch. All right. What's going on, big dog? Philly OG. Appreciate you being here. All right, let's get back to it.
Section 5 of the 14th Amendment has here that gives Congress the power to enforce the article, the 14th Amendment, by appropriate legislation. Does that give Congress room here, or do you not think so?
I do.
Yes. He should have said yes. That gives Congress room to kind of do what they want. Because remember, the 14th Amendment is an amendment to Article 1, Section 2. Right? Article 1, Article 2, Article 3. Legislative, executive, judicial. Article 1 is legislative. Article 2 is executive. Article 3 is judicial. Separation of powers, checks and balances. All right, so those are your foundations.
You think that a ruling in our favor would leave room for Congress? I don't think you'd have to rely on Section 5. I think that Congress has its own inherent power to grant citizenship by statute. So if the court were to rule in our favor for the classes of individuals that they say should be covered, Congress has the latitude to do that.
How much room do you think Section 5 gives, if any, and it may not be any, Congress to interpret the phrase subject to the jurisdiction thereof, or to define that? Is that relevant at all?
It's a great.
Right. So what Justice Kavanaugh is saying, he said, what room does it give it? He said, if any at all, and he really don't believe it gives them any room to do any of that. Right. So what he's referring to is making it up as they go. And this is one of the main issues that I have. I mean, when they talk, it's so just bland. You're not even getting to the meat. You're just surface talking in codified language where the people really can't understand, and then it leaves somebody up to interpret what they're saying. It's like they're speaking a whole different language, which they are.
Question I'm thinking about for the first time. I assume it would be governed by the congruence and proportionality test from this court's case law. How that would apply here, I don't know. And I don't think it's presented, because our contention is that the statute means exactly the same thing. If anything is congruent and proportional, it's that. And I think the court held that in the United States against Georgia.
You've mentioned several times the practices of other countries.
Now, he's saying means the same thing. What does it mean the same thing to? What is he referring to? It said it means the same thing. They never mentioned what it means the same thing to. It can't be the Civil Rights Act. It has to be Article 1, Section 2.
And that's obviously, as a policy matter, supports what you're arguing here. But obviously, we try to interpret American law with American precedent based on American history. That's certainly what I try to do, and I think you try to do. And so why should we be thinking about, even though as a policy matter, I get the point, thinking about, gee, European countries don't have this, or most other countries, many other countries in the world don't have this. Doesn't that, I guess I'm not seeing the relevance as a legal, constitutional, interpretive matter necessarily, although I understand it's a very good point as a policy matter.
Yeah,
all right, so what Trump has been saying all this time, this is what we're dealing with, the food and everything. The food that they allow into the United States and on this continent, they do not allow in almost every other country. I mean, some of the stuff, and like I said, Robert Kennedy Jr. was talking about it, a lot of the stuff that they actually allow. And I'm just talking about food. I'm using food as an example, let alone a lot of other stuff. It's not allowed here. So Trump is like, wait a minute, we funding all these people and we're protecting them. We're giving them money and we protecting our investment, right? We're colonies, these companies that was just set up, and it's been a long time thing. This is just where people need to get into American history, not American government history. We talk about American history, period. You'll understand what Trump is saying. We're funding them, we're supplying them product, and we're protecting them. Every time they have a problem, guess who they call? But all these former presidents who pretty much have dual citizenship in my mind, based on how they act, is because they're not putting America first. They're pretty much saying, we don't care about history. We're not from here anyway, so we could do what we want. We pretty much have all of the corners and traps of things covered that nobody knows whether they're coming or going. So they don't understand where the money is, how the money's created, how this is being done, what they don't know what their rights are. And you know who I mean by they, because everybody else doing pretty damn good. I mean, they doing pretty damn good. But there's another group of people that's just surrounded by this and that and this and that.
I largely agree with that, and you can view it as being raised preemptively, defensively. I'm going first, but obviously the other side of their amici say classes of individuals that they say should be covered. Congress has the latitude to do that.
How much room do you think Section 5 gives, if any, and it may not be any, Congress to interpret the phrase subject to the jurisdiction thereof, or to define that? Is that relevant at all?
It's a great question, and I'm thinking about it for the first time. I assume it would be governed by the congruence and proportionality test from this court's case law. How that would apply here, I don't know. And I don't think it's presented, because our contention is that the statute means exactly the same thing. If anything is congruent and proportional, it's that. And I think the court held that in the United States against Georgia.
You've mentioned several times the practices of other countries, and that's obviously, as a policy matter, supports what you're arguing here. But obviously, we try to interpret American law with American precedent based on American history. That's certainly what I try to do, and I think you try to do. And so why should we be thinking about, even though as a policy matter, I get the point, thinking about, gee, European countries don't have this, or most other countries, many other countries in the world don't have this, doesn't that? I guess I'm not seeing the relevance as a legal, constitutional, interpretive matter necessarily, although I understand it's a very good point as a policy matter.
Yeah, I largely agree with that, and you can view it as being raised preemptively, defensively. I'm going first, but obviously the other side of their amici say, make it a prediction, end of the world type predictions, and our point is, it's a very small minority of countries. Almost every country, and certainly all European countries, have a different rule, and the world hasn't ended there.
The other side, last one, the other side relies heavily, of course, on Wong Kim Ark, and you disagree with their interpretation. Oftentimes, when you are dealing with a constitutional precedent like this, you might argue, we disagree with that interpretation, but if you adopt their interpretation or agree with their interpretation of that precedent, you should overrule it. And you haven't made that argument here, and I'm just giving you an opportunity to explain why you haven't.
Because we think it's totally unambiguous in Wong Kim Ark that the holding relates to domiciled aliens. And so we strongly agree with the holding. We think domicile was the touchstone, and we think that's not a coincidence for the reason I maybe speculate a little bit when I was talking to Justice Gorsuch about, how the dissent raises this, and then the majority is like, we're putting domicile in there, so we know that the absurd conclusion that they say would come from this isn't there. But also domicile as kind of the sort of relationship that creates this relationship of allegiance that makes you part of a political community if you're an alien from another country. That's
Domicile makes you a part of a political community. All right.
Deeply rooted in their understanding what they're doing. They've talked about domicile in Yickwo against Hopkins in the 1892 and 1893 cases, and there's this deeply rooted understanding, again, that goes all the way back to the early 19th century. So we think that's a really important conception. So I mean, we disagree with some of the dicta in Wong Kim Ark that we discussed, and we think there's dicta that goes our way that the other side overlooks. And we're not asking the court to overrule dicta. We just say don't follow erroneous dicta and don't apply it to this brand new situation that was not decided in Wong Kim Ark.
Thank you.
Justice Barrett?
So General Sauer, I want to zoom out a little bit and think about use solely and use singular. So as I understand it, at the time of the 14th Amendment, those were the two dominant approaches, use solely.
In Wong Kim Ark.
Thank you.
Justice Barrett?
So General Sauer, I want to zoom out a little bit and think about use solely and use sanguinis. So as I understand it, at the time.
In Wong Kim Ark.
Thank you.
Justice Barrett?
So General Sauer, I want to zoom out a little bit and think about use solely and use sanguinis. So as I understand it, at the time of the 14th Amendment, those were the two dominant approaches, use solely, the English common law, roughly following the soil, use sanguinis, roughly citizenship following the parents. Now, use solely was very generous on the soil, the English common law, and so it extended citizenship to those born there who may not have been born of parent citizens.
All right, look, I'm not going to just put it in the chat so you guys know exactly how that's spelled. Now, I'm not going to interrupt this. I'm going to listen, and I want to see exactly what's going on. What's going on, Firekeeper? What's going on? All right. So I'm not going to interrupt this at all. I want to listen to this, and then I'll probably rewind it. It's interesting. Let's go back. All right, we're there.
In Wong Kim Ark.
Thank you.
Justice Barrett?
So General Sauer, I want to zoom out a little bit and think about use solely and use sanguinis. So as I understand it, at the time of the 14th Amendment, those were the two dominant approaches, use solely, the English common law, roughly following the soil, use sanguinis, roughly citizenship following the parents. Now, use solely was very generous on the soil, the English common law, and so it extended citizenship to those born there who may not have been born of parent citizens. But jus sanguinis, if parents who were citizens and had a child abroad, then that child's citizenship followed the parents. So one thing that's puzzling me about your argument when I think about the ratification of the 14th Amendment, in many ways it would have made sense for them, and you acknowledge the jus sanguinis in citing Vattel, it would have made sense in some ways for them to say, okay, we're going to follow, if they wanted to accomplish what you're saying they wanted to accomplish, you could say, well, we're going to follow jus sanguinis because we're going to make it all ride on parentage. But instead, I mean, the 14th Amendment, we're talking about subject to the jurisdiction thereof, but it also says born in the United States. So you have the jus soli kind of point there, but you're saying it narrowed that point by tying it to the citizenship of the parents, at least as to soil. But I take it you're not arguing that United States citizens who have children born abroad would qualify for birthright citizenship. So it's kind of a narrower view of both the traditional jus soli rule and a narrower view of the jus sanguinis rule. So why would they have done that? And if they were going to invent an entirely new kind of citizenship, like an American brand, why wouldn't we have seen more discussion of that in the debates?
I think you do. And I would say, I think the right way to conceptualize it, it is a modified jus soli. Because even the British sources don't just say you're born here, you're a citizen. They say you're born here and you have to be under the protection of the sovereign. You have to have a relationship of allegiance. Allegiance is the word in Calvin's case.
But they don't focus on the parents. It's the child. And your approach focuses on the parents' allegiance.
Yeah, I'm not sure that that's true of the 19th century
sources. It seems a little
sources,
ambiguous, and I'm going to ask your friend on the other side of that question.
Let me point out then that there are two criteria. One is birth on the soil, and the other is allegiance or allegiance. What we have is birth on the soil remains the same, right? And so they are, and that's why so much of Wong Kim Ark is actually we agree with, because they are adopting a modified British rule. They are not going the French rule, that Vattel talks about, where it's like who's the citizen. That had to be done by statute, as you pointed out, which it was in 1401. But what they've got is they say birth in the United States and subject to the jurisdiction thereof. That is talked about as allegiance, allegiance, allegiance in the congressional debates, but they were clearly not incorporating the British feudal monarchical conception of allegiance where it's indefeasible. I mean, going back to the early 1700s, our nation had repudiated the notion that citizenship is indefeasible. The expatriation statutes from the late 1700s reflect that. And again, you look at the 1868 congressional report that we cite there, this is the same group of congressmen, Republican congressmen, and they say things like the U.S. Constitution itself is proof that Blackstone's theory of allegiance was not accepted. So they accept birth on U.S. soil, but then they take the concept of allegiance and give it its Republican, Democratic, American understanding. And that's very, very, I think that makes a ton of sense.
Okay, and let's talk about its applications. So, there are some, I can imagine it being messy in some applications. So what would you do with what the common law called foundlings? The thing about this is then you have to adjudicate. If you're looking at parents, and if you're looking at parents' domicile, then you have to adjudicate both residence and intent to stay. What if you don't know who the parents are?
I think there are marginal cases. That one, I think, has the benefit of being addressed in 1401F, where it talks about.
Yeah. But what about the Constitution?
Under the Constitution, it's I mean, look, domicile is a constitutional standard in all kinds of other situations.
Well, and it's hard.
Diversity, jurisdiction, personal jurisdiction. Sorry.
Well, yeah, and personal jurisdiction. I mean, 1332, diversity jurisdiction. And the thing is, it has to be litigated because it turns on intent. And both the virtue of both jus soli and jus sanguinis, whichever one you pick, it's a bright line rule. How would it work? How would you adjudicate these cases? You're not going to know at the time of birth for some people whether they have the intent to stay or not, including U.S. citizens, by the way. I mean, what if you have someone who is living in Norway with their husband and family, but is still a U.S. citizen, comes home and has her child here and goes back? How do we know whether the child is a U.S. citizen because the parent didn't have an intent to stay?
I'd say make 2 points, one practical, one legal. The practical point is under the terms of this executive order, you don't have to, because the executive order turns on objectively verifiable things, which is immigration status. Are you lawfully present but temporarily present, or do you have an illegal status? So those kind of taking evidence, so to speak, under subjective intent wouldn't be done. And as to the constitutional point, obviously domicile is baked into a lot of constitutional and legal concepts, and there may be situations situations where facts are determined. But if you look at the guidance that all the agencies did after this court in Casa said the agency could go forward and issue guidance, the guidance provides, I think, very, very clear, objective, verifiable approaches to doing this. And so as a practical matter, I don't think it's presented by this executive order.
Thank you, General.
Justice Jackson?
The April 15th tax deadline is coming fast. You can skip the line and a turbo.
My bad. Yeah, I know. She do got Haitian kids. I'm like, how you do that one? How you do that one? See, this is where you get everybody's personal perspectives in this thing. Yeah, William Blackstone's commentary. Yep, nonetheless. But yeah, this is where, you know, people's personal interests come involved. You know, this is where you can listen to everybody and see if they have any type of personal interest involved, right? I wouldn't call it necessarily being biased. I just think that their personal interest affects their questions because they're going to have to be raised into a place. They all are now, everybody that's in some form of office in any of the three articles, any of the three branches, now have this idea of superiority, power. But it's always power to the people. Power is granted. These powers have been granted to you to exercise on behalf of the people. With allegiance also to the government for which it stands. Now, that's on them. But at the same time, they're still trying to figure it out because they don't know. They actually take some of this information and they literalize it and don't look outside the scope of what the so-called framers, you know, who those people are, intended. That whoever that I bind to, right? That's just like a simple, and it's a quick digression, sidebar a little bit. But it's just like if I have a contract with you, business, and then next thing you know, I bounce and I give my contract to somebody else. I sell my contract, and this other person say, okay, now you owe me. Like, wait a minute. I didn't contract with you. How you gonna tell me I owe you now? Does that give you all rights and purposes to cancel the contract? You can rescind it. You can revoke it based on the fact that that language wasn't in the contract, in the agreement. On top of that, if you say that you're going to be selling this contract over to somebody else because you want out of it, you got to ask me for permission. See? This is what's going on here. They're making up their own rules. And a lot of these people are so nervous right now in these offices because they've actually drank the Kool-Aid to think that they can actually do whatever they want to do within the governmental system to usurp or to circumvent. Circumvent is better, to circumvent the original agreements.
In this case, and it boils down.
It's a bright line rule. How would it work? How would you adjudicate these cases? You're not going to know at the time of birth for some people whether they have the intent to stay or not, including U.S. citizens, by the way. I mean, what if you have someone who is living in Norway with their husband and family, but is still a U.S. citizen, comes home and has her child here and goes back? how do we know whether the child is a U.S. citizen because the parent didn't have an intent to stay?
I'd say make 2 points, one practical, one legal. The practical point is under the terms of this executive order, you don't have to because the executive order turns on objectively verifiable things, which is immigration status. Are you lawfully present but temporarily present, or do you have an illegal status? So those kind of like, taking evidence, so to speak, under subjective intent wouldn't be done. And as to the constitutional point, obviously domicile is baked into a lot of constitutional and legal concepts, and there may be situations where facts are determined. But if you look at the guidance that all the agencies did after this court in Costa said the agency could go forward to issue guidance, the guidance provides, I think, very, very clear, objective, verifiable approaches to doing this. And so as a practical matter, I don't think it's presented by this executive order.
Thank you, General.
Justice Jackson?
Good morning, General. So I guess I am looking at your position in this case, and it boils down to requiring us to do at least these 2 things. One is believe that the framers were not importing the common law rule and understanding of birthright citizenship. And the second is to believe that what they were doing was departing from that common law rule in the way that you suggest. That is, they were seeking to have this turn on domicile. I think you have a number of hurdles to accomplish those 2 things. One of which I think is that when we look at this court's case law, and no one I think has mentioned Schooner's Exchange, but it appears that that was an 1812 case in which it seems as though the court had already accepted at the time of the ratification of the 14th Amendment that the allegiance that you were talking about was the English common law rule. That, in other words, allegiance meant that you are covered by the laws of the jurisdiction, that you can rely on that jurisdiction's protection. That's what allegiance meant. Now, you're saying today, no, allegiance meant something about loyalty or that kind of idea. But if the Supreme Court had, prior to the 14th Amendment, established that allegiance meant the common law definition, I think your first hurdle is to help us understand why we would believe that when the 14th Amendment was ratified, the framers weren't just incorporating what we had previously said it meant.
Page 5. '72 of the congressional record directly addresses this. They say the
words allegiance meant that you are covered by the laws of the jurisdiction, that you can.
I was muted the whole damn time. I'll be dang. All right, so look, 14th Amendment, I'm not going to be long like I did last time. So the 14th Amendment is the amendment to Article 1, Section 2. Why? Because you got Section 2, but then you got Clause 1 through 5. I think it's Clause 1 through 3 or something like that. But Section 2, Clause 3 deals with Indians not taxed, enumeration, and citizenship. 3/5 persons and the locations of the places, right? Which at that time was the 13 colonies. The 14th Amendment, Section 2, mirrors Article 1, Section 2, Clause 3. Indians not taxed. All right. Outside of that, it still deals with citizenship, enumeration, so on and so forth. But at the time, it was for the people that actually served in the military, fought in the alleged war, and then they pledged their allegiance and then came in. So that's the whole focus. So she went through the whole gamut, but that's pretty much what she was focusing on. Did the 14th Amendment reiterate, or in her mind was pretty much just a reiteration and confirmation and a continuation of Article 1, Section 2, Clause 3 in dealing with birthright citizenship, right?
And rely on that jurisdiction's protection. That's what allegiance meant. Now you're saying today, no, allegiance meant something about loyalty or that kind of idea. But if the Supreme Court had, prior to the 14th Amendment, established that allegiance meant the common law definition, I think your first hurdle is to help us understand why we would believe that when the 14th Amendment was ratified, the framers weren't just incorporating what we had previously said it meant.
Page 572 of the congressional record directly addresses this. They say the concept of temporary and local allegiance from the Schooner Exchange is what is meant by, or temporary and local jurisdiction from the Schooner Exchange is what is meant by the word jurisdiction in the 14th Amendment. Senator Trumbull says, I thought about saying owing allegiance, but again, quote, there's a sort of allegiance from persons temporarily resident in the United States whom we have no right to make citizens. So he expressly and consciously rejected reliance on Schooner.
What do we do with, I mean, that's a debate and it's a discussion, very valid, but then we have a subsequent debate between Fessenden and Wade where the same concept comes up and it becomes clear, at least from Senator Wade's perspective, that that's wrong. So Fessenden, and I'm not sure whether these are senators, I apologize. Fessenden says, suppose a person is born here of parents from abroad temporarily in this country. Wade responds, the senator says a person may be born here and not be a citizen. I know that is so in one instance, in the case of the children of foreign ministers who reside near the United States, et cetera, et cetera. So it appears as though in that exchange, at least Senator Wade believed that the English common law understanding of what it means to have allegiance, to be a temporary person on the soil was what was being adopted.
Yeah, that exchange strongly supports us. If you look at it in context, Senator Wade has introduced a version that says only birth on U.S. soil and doesn't have any allegiance or jurisdictional element to it. And so Senator Fessenden stands up and says, well, that can't be right because, you know, obviously, what about the children of temporary visitors? It has this, you know, it's another one of these statements that has this appeal to a background understanding that we all agree that the temporary visitors, their children do not become citizens. And then Senator Wade has to kind of backtrack and say, well, what are the children of ambassadors? And in the end, Congress does not adopt Senator Wade's proposal. So we think that to the extent you can draw an inference from that, the inference strongly supports.
All right, well, let me just ask you about why we wouldn't see in the 14th Amendment anything about parental allegiance. Several of my colleagues have talked about the fact that your view of this turns on what the status of the parents are and not the child, as would the born in the United States view of it. Can you help us understand why we wouldn't expect to see a mention of parents in the text of this amendment?
I think it was well understood that, for example, children cannot, newborns cannot form domicile. So it followed every 19th century.
That assumes domicile is in the test. And I'm asking you, how do we know that Congress did adopt the test that you say it adopted.
Yeah, when you're looking at 19th century conceptions of allegiance, the notion that the allegiance, again, we say domicile is instantiating the concept of allegiance for aliens as opposed to citizen. All of that, the 19th century understands the newborn's domicile, its allegiance follows the allegiance of the parents. And I point out that their theory relies on parental allegiance as well, because they recognize the exceptions for, hostile invading armies, for tribal Indians, for ambassadors. Again, the child's allegiance status, even on their view, turns on the status of the parent.
What do we do with Professor Mueller's amicus brief and the historical record and the fact that even at times in this country where we understood that the parents were declared enemies of the United States, I'm talking about World War II and Japanese internment, babies born in that circumstance were given birthright citizenship. So it seems as though this concept of allegiance of the parents really wasn't driving birthright citizenship, at least at this period of our history. So are you saying this is wrong, or they shouldn't have gotten birthright citizenship?
Well, if they were domiciled here, yes, they should have. If they were temporarily present, then no. But the executive practice we can see from the 1930s.
How does the temporary presence run with your concept of allegiance? I'm not sure I understand. So can you be?
See, she wants to argue and cut him off, and she acts like she wants to answer, but does she want the answer? She's not asking the questions that need to be asked. What is the basis? I mean, she threw it out there in the beginning, at the end. She just slid it in at the end. Is the 14th Amendment properly introduced and submitted to attach to the Bill of Rights? The 14th Amendment in the Bill of Rights, right? You got 1 through 10, 11, 12, 13, 14, 15, 16, everything that goes along. These amendments deal with all different forms of fashion. Article 1, Article 2, and Article 3. Really, Article 1 and Article 2. Usually Article 3, not too much. But most of those things are Article 1 and Article 2 issues. But she doesn't want to get an answer. To me, is the 14th Amendment constitutional? Was it put in place to conflict with the original articles in the Constitution? Or is it aligned with the Constitution? And if it is Congress, because the thing is about Congress, is Congress properly utilizing it? Or are they weaponizing it for other means? That's the question.
Be clear, are you saying that only people who are domiciled here, as you define it, can form the necessary loyalty to the United States?
It's not allegiance is not a question of subjective loyalty.
Okay.
Oh, it is something you owe. It's a reciprocal relationship between the citizen, whether they want it or not, they have that allegiance. And I think it's powerfully.
On the basis of what?
Domicile. I mean, that's what it says in so many words in the Venus and the Pizarro. It says, look.
See, but here's the thing. See, she's being aggressive because she's thinking from a slave mentality. She's not thinking as an equal. She's thinking like a slave right now. On the basis of what? I mean, calm down, lady. Calm down. It's going to be all right. What is the bottom line? If you are a foreigner and you come into another place that is foreign to you, you don't speak the language, you don't write the language, you don't know the customs. What do you have to do? You got to learn the language. You got to know the customs. All right. Got to learn how to write, read, all those things. But at the end of the day, it's like, what point are you trying to, what point are you trying to make, and what are you really trying to find out? You know for a fact that most of these people, even this guy right here, is a foreigner. I bet that he might be a second generation, maybe a third generation American citizen, United States citizen, whatever. He doesn't even fall under the birthright citizenship clause because it ain't been amended since 1890. You have the 1790 Naturalization Act, and you have the 1890 Naturalization Act. And it deals with free white persons. Those are the ones to be naturalized, and you got to fall under those categories. So you're talking about 1790, and then you have 1890. And we're going to get into that. We're going to show what it is. But calm down, lady. You'll be all right.
If you're talking about an alien, if they're just temporarily passing through, no, they don't have allegiance. But if they've made it their permanent home, they become part of our political community, and they are analogous or akin to citizens.
All right, just quickly, because I'm mindful of the time. What?
Lubis at the Lubis. I'm going to address this one time. Who is granted birthright citizenship? Let me say it a different way. Who is birthright citizenship applied to? Who qualifies? Now, I know that you would like to know, would like to know, what's the point? Well, it's because there's a lot of people over here that don't supposed to be over here. At best, they're over here to work and go home. But no, people are squatting. You have to be this specific or fall under this category, specific category, to be a birthright citizenship. On the other end, it's been shown in this oral argument that Indians are not subject to the United States and do not fall under birthright citizenship. So this is an issue with who? Immigrants, slaves, more importantly, children of slaves. Brought over here, maybe trafficked over here by their parents. Got it? So you might want to go back and look at this thing, Lubis. This ain't me talking. What I'm doing is I'm breaking it down like I like to break it down. All right? There you go. Now hush.
What do you do with Juan Kim Ark's statement that birthright citizenship is applying, quote, independently of a residence with intention to continue such residence, independently of any domiciliation? I know that they use domicile, it's a fact in the case, but that's not a part of their holding. It's not what the reasoning turns on.
I believe you're quoting from page 693 of that opinion. It goes on to say, not citizen terms on that, but the duty of obedience to our laws. It doesn't take the further step at that point and say, therefore, if you have temporary and local allegiance, you're a citizen. And immediately before that, you have that page 693 summary of the court's holding where it says
You say
domicile.
incorporates a domicile requirement.
That is the holding. It's definitely clearly expressed in the holding.
All right, one final thing, perspective. You say perspective, we're supposed to do this. Don't worry about the people who are already here and who would not qualify under your rule. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, social security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get it.
No, not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So we bringing pregnant women in for depositions. What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity. There's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases,
After the
is
fact.
directly addressed in that guidance.
After the fact,
Yes.
after their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I mean, I'm summarizing because I'm not an expert
Yes.
on computers, but there's a computer program that currently automatically generates a social security number. SSA says, look, a social security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a social security number, provided that the system automatically checks the immigration status of the parents, which they're robust data.
Uh-oh. Let's run it back. They just be talking so damn fast, man. They need to slow down.
How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, social security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get it.
No, not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So we bringing pregnant women in for depositions. What are we doing to figure this out?
No, as I pointed out.
All right, so we're going to take this frame by frame because they talking too damn fast. Try and catch this. So pregnant women for deposition. All right.
Out earlier, the executive order turns on lawfulness of status. So if
lawfulness of status. And then he said, I mean, slow, man. Cut down the coffee, bro. Cut down the coffee, the lines, whatever you doing. Cut it out. Cut it down just a little bit. Man.
you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity. There's the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, social security numbers are generated based on the birth certificate. They say.
All right. So social security numbers are generated based off the birth certificate. Now, the Social Security Administration, right, is connected to the Hague Convention. So the Hague Convention is where you deal with child support and all that. The Hague Convention plays an important role in that because the Hague Convention was created as a continuation, just like in the early 1800s when they stopped slavery, supposedly. The Hague Convention is there to protect women and children. So the Social Security Administration under Title 4D, you deal with that child support, amongst other things. But the Hague Convention addresses some of those things. I'm just kind of summarizing, paraphrasing a little bit. We don't need to get too deep on it. But back to what he just answered. He said the birth certificate number generates a Social Security number. So that means immediately there's a Social Security number created.
This can still be, for the vast majority of instances, completely transparent. You will still get
not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So we bringing pregnant women in for depositions. What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So
okay, lawfulness of status.
If you give birth to a baby in the hospital.
So lawfulness of status has nothing to do with a birth certificate or a Social Security number. This is what I'm gathering. Could be wrong.
Right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity. There's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases,
after the
is
fact.
Directly addressing that guidance.
After the fact.
Yes.
After their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I mean, I'm summarizing because I'm not an expert in computers, but there's a computer program that currently automatically generates a Social Security number. SSA says, look, a Social Security number.
So there's a computer that automatically generates a Social Security number. All right.
Non-citizens can have them if they have work authorization, so it doesn't prove citizenship.
So non-citizens can get them, but it does not prove citizenship. So a Social Security number does not prove citizenship.
We'll give you a Social Security number, provided that the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Thank you, Counsel.
Okay, so it generates through immigration and all of that. So in that immigration, if you got a birth certificate, that means that you would say definitely that the birth certificate first can be applied through immigration. So the Social Security number is going to show that there is a birth certificate, and therefore you will get a number generated through the birth certificate. Something like that? Something like that.
So,
Sacramento homeowners, are you missing out?
Ms. Wong?
Mr. Chief Justice, and may it please the court, ask any American what our citizenship rule is, and they'll tell you, everyone born here is a citizen alike. That rule was enshrined in the 14th Amendment to put it out of the reach of any government official to destroy. When the government tried to strip Mr. Wong Kim Ark's citizenship on largely the same grounds they raised today, this court said no. 30 years after ratification, this court held that the 14th Amendment embodies the English common law rule. Virtually everyone born on US soil is subject to its jurisdiction and is a citizen.
Now, you see here, Cecilia Wang. Is that really her first name, or did she just create a name that would be considered to be? I mean, pretty much sisters have names like Cecilia. See, this is what I'm saying. Wang. She keeps her national name. She keeps her family name. That makes her a foreign national. She still has her allegiance to where she comes from. You see? And she just applies Cecilia to the first name. But is that an actual birth name, or is that SS4, EIN? Or is that a name that they created just within the United States system with the birth certificate when she was born over here? And they said, oh, what's her first name? Oh, we're going to name her Cecilia. What's her last name? Wang. You keep that name, but your first name's Cecilia. All right. But her language right off the rip is saying that if they're born here, they're birthright citizenship. Why? They're a birthright citizen under the subject to jurisdiction and so on and so forth. And that's what it is. She's just saying that's what it is. That's the language. That's how it's being interpreted. That's how we interpret it. And this is the whole thing about these plenary doctrines and these doctrines of discovery, is that they take the language, attempt to misinterpret it, remix it, and see if they can get precedent on top of it. And once you create that layer, it's hard to pierce through it for somebody to overturn it.
Excludes only those cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction, even when they're in the United States. A closed set of exceptions to an otherwise universal rule. My friend has now clearly said that the government is not asking you to overrule Wong Kim Ark. That is a fatal concession, because Wong Kim Ark's controlling rule of decision precludes their parental domicile requirement. The dissent understood that, and the majority tells us 6 times in the opinion that domicile is irrelevant under common law. Lynch versus Clark was already the dominant American case on citizenship, and it held that the US-born daughter of temporary visitors from Ireland who took the baby back to Ireland with them, that daughter was a US citizen. Authorities, including Lincoln's Attorney General and Kent's commentaries, embraced Lynch, and Kent specifically talked about temporary sojourners' children being US citizens. Justice Field said in 1884 that reflected the general understanding. That understanding was confirmed by Congress with its 1940 Act. The 14th Amendment's fixed, bright-line rule has contributed to the growth and thriving of our nation. It comes from text and history. It is workable, and it prevents manipulation. The executive order fails on all those counts. Swaths of American laws would be rendered senseless. Thousands of American babies case on citizenship, and it held that cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction, even when they're in the United States. A closed set of exceptions to an otherwise universal rule. My friend has now clearly.
That's what I was looking for. That's what I was looking for. All right, let's take this all the way to the top.
Mr. Chief Justice, and may it please the court, ask any American what our citizenship rule is, and they'll tell you, everyone born here is a citizen alike. That rule was enshrined in the 14th Amendment to put it out of the reach of any government official to destroy.
That's a lie.
When the government.
Hey, what you gotta understand is ACLU It's supposed to be a civil liberties union, right? I think it's American Civil Liberties Union, if I'm not mistaken. Is that right, business? None of your business? That's what ACLU stands for, right? All right. Just let me know if I'm wrong. Give me the proper acronym.
The government tried to strip Mr. Wong Kim Ark's citizenship on largely the same grounds they raised today. This court said no. 30 years after ratification, this court held that the 14th Amendment embodies the English common law rule. Virtually everyone born on U.S. soil is subject to its jurisdiction and is a citizen.
That's not true. That's not true. She's saying that everybody born here is considered to be a citizen. Just because you're born here, you automatically are. So that means everything gets cut out. Born here, citizen. That's it. That's wrong.
It excludes only those cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction, even when they're in the United States. A closed set of exceptions to an otherwise universal rule. My friend has now clearly said that the government is not asking you to overrule Wong Kim Ark. That is a fatal concession because Wong Kim Ark's controlling rule of decision precludes their parental domicile requirement. The dissent understood that, and the majority tells us 6 times in the opinion that domicile is irrelevant under common law. Lynch versus Clark was already the dominant American case on citizenship, and it held that the US-born daughter of temporary visitors from Ireland who took the baby back to Ireland with them, that daughter was a US citizen. Authorities, including Lincoln's Attorney General and Kent's commentaries, embraced Lynch, and Kent specifically talked about temporary sojourners' children being US citizens. Justice Field said in 1884 that reflected the general understanding. That understanding was confirmed by Congress with its 1940 Act. The 14th Amendment's fixed, bright-line rule has contributed to the growth and thriving of our nation. It comes from text and history. It is workable, and it prevents manipulation. The executive order fails on all those counts.
Workable. So that means able to be worked. Right? It's workable. This is where, he keeps saying, the Solicitor General keeps saying unambiguous. What she's saying is it is ambiguous. That's the point she's making. That at the time with this Ark situation case, they really couldn't get a clear understanding of what the law was and how it applied. Because they used the term persons. But what they did know is who it didn't apply to. Who it definitely didn't apply to. And that was the tribal Indians. They knew it didn't apply to them. Birthright don't apply to them. But there's some issue that they're dealing with in regards to who it does apply to. Because you're using persons. You're using citizen. It's enumeration. And all these terms that they're using, you can see them reflected in SS5 and SS4. This is why if you look at SS5, this is why they put in this Latino thing. Right? Hispanic Latino thing. And they ask that question, are you Hispanic or Latino or something like that? And you can check that box. Anybody can check that box. and it's separate. It's over to the left. And then you have your box of these other things. You know, Asian American, Chinese American, Asian American, and white, American Indian, Hawaiian Native, all this other type of things that they have. And they have a other box. So this is not, it's not a bad thing, you guys. This is the United States system. It was set up to be ambiguous. The United States was set up as a corporation, and it was set up as a plantation for people to come in and work and then go home. Do business in any form or fashion, and then go home to your land. If you was here domiciled as a foreigner and not natural on the land, you had places where you can go, like ghettos, tenements, plantations of the sort. But once your job was done, you can decide to go back home. Because as you got done with you, when you was talking about the Irish person was here, did some work, and took his child back home, because they're talking about the child. They're not talking about adults. You're talking about the children, the babies. She's not going to talk. She wants to mention that little thing where this is where the issue comes in, of what they don't want to really address. Like, what is the United States? What is it? Trump has no problem saying that it is a corporation. He says it all the time in his fake ass Freudian slips. It's a corporation. Our corporation, I mean our country. Our corporation, I mean our country. It is a colony. It is here for a specific reason.
Laws of American laws would be rendered senseless. Thousands of American babies will immediately lose their citizenship. And if you credit the government's theory, the citizenship of millions of Americans, past, present, and future, could be called into question. All of this tells us the government's theory is wrong. I welcome the court's questions.
There are 5 exceptions to citizenship that you do accept.
Yes, depending on how many you count, Justice Thomas, how you count them.
What is the underlying rule of law that you use to connect these 5 exceptions?
Sure. So as I just said, all of the exceptions involve situations where that US-born child is not subject to the jurisdiction of the United States, because that extraterritoriality, that fiction of extraterritoriality, the interaction of another sovereign between the United States' jurisdiction and that person applies to the child as well as to the parent. Everyone else born in the United States is subject to the United States' jurisdiction. To answer Justice Barrett's question to my friend, that's what sets those exceptions apart from other US-born persons.
We've heard a lot of talk about Wong Kim Ark.
5 exceptions.
Sure, could be called into question. All of this comes from text and history. It is workable and it prevents manipulation. The executive order fails to credit the government's theory. The citizenship of...
There are 5 exceptions to citizenship that you do accept.
Yes, depending on how many you count, Justice Thomas, how you count them.
What is the underlying rule of law that you use to connect these 5 exceptions?
Sure. So as I just said, all of the exceptions involve situations where that US-born child is not subject to the jurisdiction of the United States because that extraterritoriality, that fiction of extraterritoriality, the interaction of another sovereign between the United States' jurisdiction and that person applies to the child as well as to the parent. Everyone else.
That was a big word salad. She didn't say nothing there. She ducked and dodged that question. What is the rule of law? Extraterritoriality and all this, the sovereign and this. What are you saying? And then she talks about a fictional something. Let's hear this again. This is Word Salad 101.
Could be called into question. All of this tells us the government's theory is wrong. I welcome the court's questions.
There are 5 exceptions to citizenship that you do accept.
Yes, depending on how many you count, Justice Thomas, how you.
He said a specific number, 5. Now, she's manipulating this because obviously that's disrespectful. You talk to me as if I didn't read your brief. I've read it. So you're talking about 5. And you just had your opening monologue. I've read it.
Count them.
What is the underlying rule of law that you use to connect these 5 exceptions?
That's the question. What is the underlying rule of law that you claim to connect these 5? See, Thomas already knows what time she's on. And you see, he just jumped over that and just said, I'm going to my next question. Then get stuck into a debate and argue. So it could be a bait and switch.
Sure. So as I just said, all of the.
Sure.
Exceptions involve situations where that US-born child is not subject to the jurisdiction of the United States.
Now, when she's saying a U.S.-born child, right? It's the language here. U.S.-born child. She didn't say United States child born or a child born in the United States. She used a misnomer. See, the bait and switch. Jurisdiction thing. Because it's about to come after this jurisdiction thing. U.S. born child. Does that exist? What does that mean? But when you on a level, right, it doesn't have to be a long, drawn out debate because I already know better. I'm hearing what you're saying, and I know you just made up something.
Because that extraterritoriality, that fiction of
extraterritoriality. What is that? And then she says, fiction. Where are we at here? We have 11109. Let's go back to boom.
Accept.
Yes, depending on how many you count, Justice Thomas, how you count them.
What is the underlying rule of law that you use to connect these 5 exceptions?
Sure. So as I just said, all of the exceptions involve situations where that US-born child is not subject to the jurisdiction of the United States because that extraterritoriality, that fiction of extraterritoriality.
So the extraterritoriality or the fiction of the extraterritoriality.
The interaction of another sovereign.
So the extraterritoriality or the fiction of the extraterritoriality, and then she jumps into a whole nother lane. It's classic.
What is the underlying rule of law that you use to connect these 5 exceptions?
Sure. So as I just said, all of the exceptions involve situations where that US-born child is not subject to the jurisdiction of the United States because that extraterritoriality, that fiction of extraterritoriality, the interaction of another sovereign between the United States' jurisdiction and that person applies to the child as well as to the parent.
What?
Everyone else born in the United States is subject to the United States' jurisdiction. To answer Justice Barrett's question to my friend.
Wait a minute, lady. I'm asking you the question here. Why are you running? Why are you running to Comey Barrett? Why are you running over there? She'll get her chance. You don't run.
That's what sets those exceptions apart from other US-born persons.
We've heard a lot of
US-born persons. See?
talk about long Kmark, and you dismiss the use of the word domicile in it. It appears in the opinion 20 different times, and including in the question presented and in the actual legal holding. And the government doesn't want it to be overruled because it's willing to rely on that particular fact in that case. Isn't it at least something to be concerned about, to say that since it's discussed 20 different times and has that significant role in the opinion, that you can just dismiss it as irrelevant?
Well, Mr. Chief Justice, I think we have to look at what the controlling rule of decision is in Wong Kim Ark. Justice Gray takes pains in the majority opinion to set out his analysis. He first starts with a premise that in construing the 14th Amendment Citizenship Clause, we look to the English common law. That was the rule that applied from the colonial era on, at least for the colonists and for European immigrants. He then says, look, Chief Justice Marshall tells us in the Schooner Exchange what subject to the jurisdiction means, again looking to the English common law. Under English common law, if you are born in the dominions of the sovereign, you owe natural allegiance, and those who are present in the dominions of the sovereign owe temporary allegiance for as long as they're present. The only exceptions, again, at common law were ambassadors, people born on foreign ships, and people who were born during periods of foreign occupation. He then gets to the government's favorite page, 693, where he says, look, we have had this rule in the United States as to citizenship, at least for white Americans, from before independence. The purpose of the 14th Amendment was to embrace that universal rule of birthright citizenship, to embrace and incorporate the common law exceptions with the single additional exception of the pre-existing exception for tribal Indians that we had in the United States, which is an analogous exception, and that's the closed set of exceptions. You can't make sense of the holding in the case without looking to the controlling rule of decision, which is the common law. And I think my friend agrees that under English common law, domicile was not relevant, and the children born to temporary visitors in the territory of the sovereign were always considered birthright citizens.
Well, Ms. Wong, I mean, everything you say strikes me as, yeah, that's the way I read it too. But then what are those 20 domicile words doing there? Like, you can, take some of them and say, they were just summarizing the facts of the case, but not all of them. And why did they keep on, why did they sprinkle that in the opinion?
Well, I think, again, those were the stipulated facts in the case. And it's clear we have textual evidence in the majority opinion that they were simply saying this is an a fortiori application of that controlling rule that comes from the English common law. Justice Gray writes, again, after setting out the English common law rule and the exceptions, with the single additional exception for children of members of Indian tribes, that the amendment in clear words and manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. And as was pointed out earlier, the very next part of that same paragraph,
domicile words doing there. Like you can, take some of them and say, they were just summarizing the facts of the case, but not all of them. And why did they keep on, why did they sprinkle that in the opinion?
well, I think, again, those were the stipulated facts in the case. And it's clear we have textual evidence in the majority opinion that they were simply saying this is an a fortiori application of that controlling rule that comes from the English common law. Justice Gray writes, again, after setting out the English common law rule and the exceptions, with the single additional exception for children of members of Indian tribes, that the amendment in clear words and manifest intent includes the children born within the territory of the United States of all. And it's clear we have textual evidence in the majority opinion that they were simply saying this is an a fortiori application of that controlling rule that comes from the English common law. Justice Gray writes, again, after setting out the English common law rule and the exceptions, with the single additional exception for children of members of Indian tribes,
right? The English common law, the exception, the only exception, the only exception. Here we go. Point blank, period. So, under the circumstances, we'll finish off with this and then we'll stop it, is that the bottom line is, don't argue something that ain't got shit to do with you. Mind your business. Or mind your business. Y'all like that? American business? None of your business? Y'all like that? Y'all like that? Mind your business. This ain't got nothing to do with you. If you're claiming something, don't argue that. You see, this has nothing to do. If you're claiming to be Indian, an American Indian, by definition, by blood right, just solely, just sanguinis, you do not need to get your blood pressure up about this topic. Has nothing to do with you. It's interesting to talk about on the other end of the spectrum, while we on the outside looking in, that they have such issues right now that Trump is like, man, tired of all this. I don't care. Yeah, I'm a second generation immigrant. Yep, fuck it. I am. Yeah, but at the end of the day, you know, my people worked, did what they did, and I'm about getting these people up out of here. You know, we actually claim they can claim homestead in the matter. I mean, but at the end of the day, they got to pay. They know they still got to pay, because whatever benefits and privilege that they was getting, it was not for them. It was not for them. So we're going to finish this little section off. We're going to pause it. And then I'm just going to show you just solely, just sanguinis. Look at some of these definitions so we can have a clear idea, and then I'll drop the link in the chat, and we can either converse a little bit or call it a day, man. All right, let's finish this up.
That the amendment in clear words and manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. And as was pointed out earlier, the very next part of that same paragraph, he cites to Webster talking about Thrasher's case. And he says, people who are born in this country owe allegiance independently of a residence within, foreign nationals owe allegiance independently of a residence with intention to continue such residence, independently of any domiciliation, and independently of taking any oath of allegiance, which is totally contrary to both the government's theory of dual allegiance or partial allegiance and to the theory of domiciliation.
I mean, I might agree with you if domicile had simply been sprinkled in the opinion, but in Wong Kim Ark, it's a long opinion, but it begins by saying, here's the question, and it ends by coming back to the question. And it says, here's the question stated at the beginning of the opinion, namely whether a child born in the United States of parents of Chinese descent who at the time of his birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business, and he states the diplomatic exception, and he says, for the reasons above stated, this court is of the opinion that the question must be answered in the affirmative. So why put domicile in? Sometimes it's hard to figure out what is the holding of the case. Here he tells me of the case. Why put domicile in there? It's just something.
To continue such residence of dual allegiance or partial allegiance and to the theory of domiciliation.
I mean, I would.
We're gonna end it off on this guy because he kind of came in hot. So let's see what he's talking about.
I might agree with you if domicile had simply been sprinkled in the opinion, but in Wong Kim Ark, it's a long opinion, but it begins by saying, here's the question, and it ends by coming back to the question. And it says, here's the question stated at the beginning of the opinion, namely whether a child born in the United States of parents of Chinese descent who at the time of his birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business, and he states the diplomatic exception, and he says, for the reasons above stated, this court is of the opinion that the question must be answered in the affirmative. So why put domicile in? Sometimes it's hard to figure out what is the holding of the case. Here he tells us this is the holding of the case. Why put domicile in there? It's just something, it's something irrelevant that he wanted to throw in. It's like, whether a child born in the United States of parents of Chinese descent who once resided at a particular address in San Francisco, who attempted to enter the country at the port of San Francisco. Why put it in if it's irrelevant?
Well, Justice Alito, I'll give you two responses. The first is that, again, it was a stipulated fact. The second is that regardless of what the judgment in the case was, which again was an a fortiori application of the rule of decision, the rule of decision in Wong Kim Ark has binding precedential effect. Even if you think that Wong Kim Ark decided the case based on the stipulated facts, you have to follow that controlling rule of decision. And if you follow that rule, you get to the same result for people without domicile. Wong Kim Ark says 6 times in the first parts of the opinion, as well as on the page the government focuses on, that domicile is not relevant.
Well,
that
Ms. Wong, on that, what do we do with the fact that after Wong Kim Ark, at least some authorities took the view that the non-domiciliary question wasn't decided, remained?
See, my issue is this. If she's trying to say domicile is not relevant, I mean, what she's saying is what they're hanging their hat on, and I know what she's hanging her hat on, squatting. we here, we're doing this, we got this, we got these instruments, so we can go ahead and do something. We can do something.
Open and even continue to press the view that domicile is required. Now, I know you've got a lot of good stuff on your side too, but what do we do with the fact that many sound legal authorities thought it remained an open question, even if one of them wasn't John Marshall Harlan?
I liked your example from Justice Harlan's lecture here in DC. So here's what I would say. All of the government's citations in their brief generally either were rejected by Wong Kim Ark expressly if they predated Wong Kim Ark.
If we're trying to understand how the legal community understood what happened in Wong Kim Ark,
Sure.
It seems to me it's a mess. So maybe you can persuade me otherwise.
I think I can, Justice Gorsuch. First, as to the post-Wong Kim Ark authorities the government cites, each one of them is inconsistent with Wong Kim Ark's reasoning or doesn't mention it at all. Most of them have very little reasoning at all. And in contrast, what we have on our side post-Wong Kim Ark is numerous federal court decisions around the time of Wong Kim Ark, between ratification and Wong Kim Ark, that said that domicile is not relevant. They cited Lynch versus Clark, which again was about the daughter of temporary sojourners. We have the 6th edition of Kent, which was cited in Wong Kim Ark, and of course was then cited after Wong Kim Ark was decided by many authorities, again, discussing temporary sojourners. Anyone who wanted to know what the law of citizenship was under the 14th Amendment after Wong Kim Ark would go to the 6th edition of Kent, where he says in that footnote on page 38 that the rule was Lynch versus Clark and temporary sojourners' children are US citizens. We have members of Congress speaking on the record on debates on immigration laws, where they were finally passing these immigration restrictions that Senator Cowan wanted. And they all stated either that Lynch was the rule, that Attorney General Bates had stated the rule, again, citing Lynch, or Kent, and stating the rule that everyone born in the US is a citizen, and saying, look, children of Chinese immigrants, these immigrants who are unwelcome, these immigrants that Congress is now trying to bar from entering the United States.
Oh, here we go with the feelings, the heartstrings.
If their children born in the United States are citizens. We have in 1896, so a couple years before Wong Kim Ark, but in 1896 State Department regulation, which said the US born children of foreign nationals are US citizens, accepting only the children of ambassadors. And then you have Marshall Woodworth, who is a US attorney who writes in a law review article that he's talking specifically about temporary sojourners' children. And he says, I don't think that's a good rule from a policy perspective, but that's the general rule.
Ms. Lang,
Okay. Now, what I'm going to do is we're going to just look up some of these, just go to these definitions, and I'll just do the whole entire screen, and we'll bring this up. We'll go to domicile. Domicile. Let me make sure I'm off mute. Yep, I'm off mute. So domicile, just basic Cornell law. Domicile refers to someone's true, principal, and permanent home. In other words, the place where a person has physically lived, regards as home, and intends to return even if currently residing elsewhere. Determining where a party is domiciled is of particular importance in the field of civil procedure. All right. So if birthright citizenship, right? If you are considered to be a United States citizen, you need to prove that you are domiciled here, meaning that this is your true, principal, and permanent home. And with intent, right? With the intent to return, even if currently residing elsewhere. You guys do your own on that. Can't hold your hand on it. Antebellum law. Just going to do some basics here. Let's scroll down a little bit. Okay, we'll just deal with antebellum law. Refers to the legal framework and political landscape in the United States before the Civil War. So anytime they're talking about antebellum, they're talking anything prior to the Civil War. But more importantly, from 1815 to 1861. So keep those dates in mind of what was going on at that time, which included significant issues surrounding slavery and states' rights. Okay, 1800 something, slavery was supposed to have been abolished in the United States. This period was marked by contentious.
Yo, we can't hear you, Big Line.
Am I on?
You're on mute. Everything
No.
on mute.
No, I'm not on mute. I think you just can't hear me. I'm not on mute. Can y'all hear me? Business? None of your business? Everybody in chat, just somebody put a thumbs up or 1, 2, 3, 4, 5. Put something in the chat if you guys can hear me. Can you hear me? Can you hear me? All right, cool. Yeah, that is not it. All right, mic check. Can you hear me?
Yeah, I can hear you. Yeah.
Oh, cool.
So you see that I put in the back chat?
Okay, cool. All right. Yes. Okay, so the chat can hear me. Yep, I got you. I'm gonna get through these definitions real quick. Let me go ahead and boom, pull that case up. All right, now we can all right, so we still live here. Boom. Okay, so it says the period was marked by contentious legislation like the Fugitive Slave Act, which heightened tensions between the North and South over the issue of slavery. We're just gonna go basics. Potentate. Now, when they was talking about potentate in the one yesterday, I pulled that up because they was talking about some African potentate. When the Solicitor General was talking yesterday in what I presented.
That's
So
throughout my paperwork, potentate.
So it says one who has the power and position to rule over others, a monarch. One who dominates or leads a group or an endeavor. One who is potent, one who possesses great power or sway, a prince, sovereign, or monarch. Now, just know that these people that was supposed to have came over here that was considered to be slaves was under an African potentate. That's what that guy has said. All right. So when you guys go back and look this over, then you'll see that. Now, the Naturalization Act of 1790 was the first law in the United States to establish uniform rules for granting citizenship through naturalization, limiting it to free white persons of good character who have resided in the U.S. for at least 2 years. This act set the foundation for future naturalization laws, which evolved over time to become more inclusive. So that is what she was talking about, the citizen clause and all that type of thing, right? Now we have just solely versus we have just solely. We ain't gonna do what under Trump administration, we ain't about to do all that. Let's just check it out, see what it says. Meaning right of soil is the right of anyone born in the territory of a state to nationality or citizenship. So it's saying is the right of anyone born in the territory of a state to nationality or citizenship. Jus soli was part of the English common law in contrast to jus sanguinis, right of blood associated with the French Civil Code of 1804. Jus soli is the predominant rule in the Americas. You see that flip? That's crazy. English, French, Civil Code, all this stuff, but then they say jus soli is the predominant rule in the Americas. Explanations of this geographical phenomenon include the establishment of lenient laws by past European colonial powers to entice immigrants from the old world and displace native populations in the new world. Along with the emergence of successful wars of independent movements that widen the definition and granting
Read that again, bro.
as
Start
a
over.
prerequisite to the abolishment of slavery since the 19th century. Listen, this right here, see, this is what I'm talking about.
Please
People,
do it over.
let me read this again. Let me read this again. Jus soli is the predominant rule in the Americas. Semicolon. Explanations for this geographical phenomenon include the establishment of lenient laws by past European colonial powers to entice immigrants from the old world and displace native populations in the new world. I mean, damn. Boy. Let's go back here. Let's go jus sanguinis. Let's go to jus sanguinis. Hold on. Let me just go ahead and go back to this, and I'll just click on jus sanguinis. Now, jus sanguinis, meaning right of blood, is a principle of nationality law by which nationality is determined or acquired by the nationality of one or both parents. Children at birth may be nationals of a particular state if either or both of their parents have nationality of that state. It may also apply to national identities of ethnic, cultural, or other origins. Citizenship can also apply to children whose parents belong to a diaspora and were not themselves citizens of the state conferring citizenship. See, this is where they're trying to work. This principle contrasts with jus soli, right of soil, which is solely based on the place of birth. Now, I'm going to go right here to Black's Law Dictionary. This is Black's Law 4th. We're going to go to, right? So we're going to go to jus sanguinis right here. It says the right of blood. See, jus soli. Then we go right up here to jus soli, or down here where you at. Right? Jus soli, the law of the place of one's birth, as contrasted with jus sanguinis, the law of the place of one's descent or parentage. It is of feudal origin. All right, so I think I have one more. Okay, so this was one of the cases that they brought up, the schooner exchange versus McFadden, which was a Supreme Court case in 1812 that established that American courts do not have jurisdiction over a friendly nation's military vessel that enters an American port. Now, if you want to talk about military vessel, it doesn't necessarily have to be a tank, a ship, or anything like that. It can actually be the body of a person. That body that comes over here could be considered to be a military vessel, right? That actually enters the port, right? People usually come over here through the ports, through ships during that time, what you call a port. Now you can apply that to an airport. Okay. The court ruled that the schooner exchange, which had been seized by France and commissioned as a warship, was exempt from U.S. jurisdiction while docked in Philadelphia due to customary international law. We'll leave it there. Here's the other one. Okay, this is Nadi's link right here. Generate a search on that and see what's going on. See what the AI quick says, and then we'll go right into just your U.S. Supreme Court Center. Come on. Okay, so it says an overview. So this case involves significant legal principles in U.S. law. Plyler versus Doe addressed the right to education for undocumented children. Hernandez versus Texas focused on racial discrimination and jury selection. And Shaughnessy versus United States ex rel Mazzei affirmed the federal government's authority to detain immigrants at the border without a hearing. Floor is yours, brother. American Business. What's going on, sister?
Hey, peace. How are you?
Hey. Okay, so before Nadi go in, is there anything real quick? I know you came up here for a reason.
Yeah, I came up here really quick because I want to basically clarify this lady who's crying, this Taiwanese lady that's crying about how the Asians were excluded. And what she didn't point out. Can you hear me? Hello?
Yep, I'm on mute. Yep, I muted up. Yep.
Okay. What she didn't point out is that the Asians were bringing this, just like how now we have those massage parlors and stuff like that. They were bringing over these women as slaves when slavery was outlawed in the United States. It was outlawed in California and it was outlawed in the United States. And they continue to bring these workers over here. You know, you see these old movies and they have like those opium houses. So they also were drug runners, you know what I mean? And they were bringing this over here, especially to places like San Francisco. And the United States said, okay, y'all not listening, because they'll come to the border talking about their Native.
Where you go, Business?
Can you hear me?
Yep, you just went out real quick. Yep. But we ended off with San Francisco. You said
Okay. So they were
Mm-hmm.
okay, sorry. Somebody keeps calling me. So they would bring these people into places like San Francisco and they wouldn't stop. And so they would say, oh, you know, we're Native Americans and to get into the United States. And so the United States just said, that's it, that's enough. So when this lady says, oh, you know, the Asians were excluded, no one ever asked why. You know what I mean? And
Yeah.
so I just want to clarify that. And I just want to give you props for reading that definition, because these people are arguing a term that purposely displaces the native communities, the real native communities of the United States. I don't remember the term. Would you say Urus something?
Yeah. You talking about Just Oli and Just Say
Yes.
When?
Yep. And it's specifically, and this is what they're arguing, this is the words that they're using, and it's specifically created to displace the Aboriginal people of the United States. So I found that really interesting. So, you know, good for you. This is really good. I'm going to drop back down now. Thank you.
All right, thank you. Nadi. That was perfect, you know, because that's what a lot of people don't understand. And this is the whole what they're saying in this whole debate or this oral argument. Domicile and children. But people are focusing on they want to focus on the adults and how she came in real aggressive, like this is what it is. You know, this is what it is, this is what it means, and this is what these people have ruled on, so on and so forth. And no, that's not the language. That's not the textual language. Now, you want to interpret it as such, and this is where the ambiguous situation comes in, because they all have to be careful. They all have to be careful, Because if it goes down to the black letter law, all of you guys are gone. Every single one of you are out of here. Do we get that part? They got to go. No, I just read that simple just solely in that Wikipedia, and they just laid it out. Man, if I'm not going to do a whole segment on that. Let me show this real quick. This was interesting. Let me show this one real quick.
Movie, man. Like, I know I'm the greatest, bro. Like, pay attention, man. They say the Indians wasn't black. They got rid of the Indians, right? So who the people on the reservations? They got rid of all the Indians. Pay attention.
Well, holy mother. What the hell do you think you're doing at that damn start, boy?
Watch that boy shit, redneck. You talking to the sheriff of Rock Ridge.
Well, now, if that don't beat all. Here we take the good time and trouble to slaughter every last Indian in the West, and for what? So then you're appoint a sheriff that's blacker than any Indian. I am depressed.
Blacker than the Indian? I thought they wasn't black. We are the Sun people. Pay attention.
Quickly, all of my plans have backfired. Instead of the people leaving, they're staying in droves.
Why don't you admit it? He's too much of a man for you, I know. You're gonna need an army to beat him. You're finished.
The army to beat him. Pay attention. Finished. Look at this. Right? They finished. They're gonna need an army to beat the Negro, the sheriff. That's what they talking about. You see all these different people? Oh my goodness. Look at all the cultures and all the different people that came to beat the American Indian. Who else there? The natives, the Mexico, the Mexican. Come on, man. Look at y'all. Look at y'all people. Look. Arabs and Africans and shit. Come on, man. KKK. But Grandma lying? Is Grandma lying? It's time to wake up and smell the coffee, people.
One nation. Five nations. One nation.
Right.
They had to get the Africans.
Right.
They had to get the Mongolians. I'm not pronouncing it right. You don't
No, it's Mongolians. No, you're pronouncing it right.
And they had to get the Asians.
Right.
They had to get the Middle Eastern.
Right.
And the Caucasian was the last. Europe was the last one.
Right.
And they all had to come together to beat us.
Right.
So one nation could beat us.
Right.
We was great rulers.
Right.
We were great rulers. And we were great builders. We did everything. And we was here in this country.
Right.
You're gonna need an army to beat the Negro. Y'all seen all them people that came around to beat us. Pay attention.